background engagements on Wednesday, I was guided to make sure that each and every member is given a chance to ask questions. The more reason I had started it this way. When on Thursday I did the same, members also complained because there was a time people said that I'm dominating. I had to take a step back and I was accused. So I want every member to have a chance. Unless there's a burning one from you as a senior Nkatabe Central, you still feel it's too burning that you need to come in? Yes, Chair. Please proceed.
Thank you very much, Chair. The question about Sigirege Hotel was about the office. I know that it happened, it took place when we were not in the office. I know that. But the question was the office of the Attorney General involved? Not you as a person, but the office. That was the question. About the meeting in Mzuzu called by Madam Colini Zamba, the question was to ask you whether you have accessed the minutes, to which you have confirmed yes. Now, I want you, if possible, Chair, to read those minutes. It's one page. Read the minutes for the benefit of the committee and the entire nation. Read the minutes. Thank you, Chair.
Thank you, Nkatabe Central. You may recall on Thursday in the evening, Blanta Chiromoni Nancholi had to go through the minutes. You want the AG to read again?
Yes.
Is this a general feeling of the committee?
Yeah. He's reading to the nation now. We're talking to the nation. Read the minutes. Don't be defensive. Read the minutes of that meeting. It's one page.
Attorney General, kindly go through the minutes that you have. Over to you.
Honorable Chair, it's actually 4 pages. Can I be guided which specific part? Is it the last part where there are action plans or? Oh, okay. So these minutes were for the meeting that was held on 6th March 2024, and the present were Ms. Colleen Zamba as Secretary to the President and Cabinet, Mr. Pris Kabondangaga as Chief of Staff at State Residences, Mr. Chizaso Nyirongo, Director of Legal Affairs, OPC, Mr. Boyd Hamela, Chairperson, Investment PSPT, and Mr. George M. Jim as Principal Officer. Let me start with action point number 1, which is under paragraph 3. So action 1 says, the fund was notified that soon it will be invited for the PSC's meeting to present the overview, so the fund must be ready. Action 2, the fund was advised to reach out to the SPC on the challenges the fund indicated, which included the delayed remittances, data disparities, the issue of past service liabilities, and non-submission of beneficiary nomination forms. Under 4, which was governance of the fund, action number 1, OPC suggested that a person from the OPC should be a trustee for easy flow of information of the fund's developments to the SPC. It was mentioned that DHRMD, which is a department under OPC, is represented. Action 2, OPC advised that the replacement of trustee Kahaki Jere, who was from the Ministry of Justice, should be through the OPC so they can play a role in scouting the replacement. And item number 5, which is status of investment of the fund. Action 1, the OPC instructed the fund to move with speed in concluding the Amaryllis transaction before the end of March 2024. Action 2, The threats for lawsuits are coming in because of the pressure the seller is getting from the lenders. To query the pressure, the fund was advised to write and give the seller the comfort letter by Thursday, 7th March 2024. Action 3, the fund to submit a workable action plan by Friday, 8th March 2024 to the OPC for their ease of follow-up. Action 4, being that the issues has raised the highest office, the fund was advised to report on weekly basis the progress made in this transaction. Make communication to the Director of Legal Services, Mr. Chizaso Nyirongo. Action 5, the fund to engage the next investment manager on the Amaryllis completion by 8th March 2024. Under conclusion and way forward, I think there's what they labeled as action plan for the critical issues, 6th March 2024. Number 1, communication on the replacement of the trustee that left to replace with OPC nominee. The status, communication that was sent to be addressed to the OPC. 2, conclusion of Amaryllis transaction with March, timelines 1 month, and the status, the issue requires board decision. 3, submission of comfort letter to the seller, timelines 3 days. 4, fund to submit the action plan to OPC on 8th March 2024, timelines 5 days. 5, resuscitating the engagement with the next investment manager on Amaryllis within a month. I suppose, Chair, that's what I could read from this report. And perhaps just to also emphasize that I have not, in my time in office of the Attorney General, I have not come across any documentation that shows that the Office of the Attorney General was involved in the purchase of Segerege Hotel. Thank you.
Katabe Central, are you okay?
Very much, Chair. Perhaps the last question would be, there's a mention there of weekly reports to OPC since the matters have reached the highest office. The one chairing that meeting was the SPC, the Secretary of the President and the Cabinet. And the reports are saying the matters have reached the highest office. Beyond OPC, how do you define the highest office? Thank you, Chair.
Thank you so much, our senior Katabe Central. Attorney General, you may take that one. As you take that one, you've also gone through a submission or a recommendation that sale was supposed to be concluded within 1 month. But this sale was concluded on 17th November 2025. In your view, was that directive followed? Over to you, Controlling Officer.
I can only think that perhaps the highest office could have been that of the President, considering that it was the Secretary to President and Cabinet. But usually I take it that documents speak for themselves. So this is me just thinking, but otherwise the document does not mention the Office of the President. Yes, the document also shows that this transaction had to be concluded within March 2024. And indeed, the sale agreement that I saw was concluded in November 2025. Suffice to say that the only thread that I am able to connect is the fact that those minutes were mandating Mr. Chizaso Nyirongo to be in contact with the fund. And from the minutes, at that time he wasn't a member of the fund. He was Director of Legal at OPC. But at the time of conclusion of the sale agreement, he was the chairperson of the fund. So I'm not sure whether I could say with certainty that that directive was followed to the letter, or maybe it just dragged on to where finally the chairperson of the fund and other trustees concluded the transaction.
Thank you so much, AG. Can we go to Lilongwe Chiwamba? Lilongwe Chiwamba, please.
Thank you very much, Chair. Allow Lilongwe Chiwamba to ask only 2 questions. AG, you wrote a letter on 28th December 2025. What exactly did you advise the fund? Secondly, AG, were you aware that asset finance managers advised the experts, provided expert advice on the same issue? Thank you.
AG, can you take those 2 from Lilongwe Chiwamba? Over to you.
Thank you, Honorable Chair and Honorable Member from Lilongwe Chiwamba. My advice to the fund was simple and straightforward. Attend to all the prudential risks, review them, find mitigating as well as management, ways of managing those issues. And this is coming from a background that transactions do normally carry risks, but that's where those making decisions must look into those risks and see whether they are mitigatable or manageable and take a decision. So that's what I did advise the fund. And of course, only to proceed with the transaction if they are satisfied that they've addressed those prudential issues. Yes, I saw some documents that showed that asset finance managers were involved in the transactions. Actually, I saw documents from FTH that were done on behalf of NICO. Now saw documents from Continental Asset Management Limited. And of course, the last one was from EMJ Advisory. Thank you.
Thank you so much, Attorney General. Can we go to Blantyre Chilomoni?
Thank you so much, Chair. Permission to interrogate the AG for about 5 minutes.
Since we already said the precedents, and I've always been giving you such a request, and it has always been granted. So permission granted. AG, what will happen? I'll not interrupt. All I'll do, I'll give to Blantyre Chilomoni Nancholi Kabula constituency. As soon as he switches off his mic, then you can switch on your mic. Immediately you're done, kindly switch off your mic. Then Blantyre Chilomoni Kabula Nancholi will come in and will proceed in that way. Over to you, Blantyre Chilomoni.
Chair, I'm going to quote the submission by the Attorney General, where he says on the page 2, we go straight to the text of the advice, where he says, in my letter to Malawi Law Society on the 28th December 2025, copied to the fund, I stated, and I quote, and the following is a quote, and indeed out of abundance of caution, and in order to ensure that members' savings are protected within the prudent investment principles of the regulatory requirement, and the board is advised to once again review the attendant risks and satisfy itself with available mechanisms for the management or mitigation thereof. Once this is done, the board is advised to proceed and conclude the transaction in the best interest of the fund and its members. In this letter, why did you say that once the issues are fixed, then the board should proceed and not may proceed?
Thank you, Chair, and thank you, Honorable Blanta Chilomoni. To begin with, the fund is founded on a trust deed, and that trust deed vests the power to invest in the trustees, and actually they have absolute discretion. So I was mindful that already the power to proceed or not to proceed is in their hands. So I needed not appear as if I'm restricting them on the powers that they have been granted absolutely by the trust deed. That is the reason why I was merely giving them the very thing that they already have. Thank you.
In your opinion, Attorney General, was the transaction conducted in accordance with the laws of Malawi, specifically the Trustees Act and the Pensions Act?
Through the Chair and Honourable Member, the compliance with, say, the Pensions Act, the regulatory framework, including directives from the Registrar of Financial Institutions, the Governor. Those were some of the issues which were raised. The prudential element of it included certain things, for instance, on concentration lists. Those come under directives from the Registrar of Financial Institutions. So those were some of the issues which they needed to attend to. So there were such issues that if they were attended to, they would have resolved the element of compliance and therefore they could proceed. So if they did not attend to those issues, at the time when they finally made payments, they would not have complied because they were issues that were actually highlighted. That's why my emphasis was, can you attend to these issues? That was, in a way, telling them that make sure that even the other regulatory issues that have been raised, which are legal in nature, must be complied with. Thank you.
In your submission, you actually indicated that the final decision maker, in any case, according to the trust deed, are the trustees, correct?
That's correct, sir.
Why do you think, in your opinion, therefore, that there was political interference between March 2024 and September 2025, specifically where Pauline Zamba had the power to instruct the board or the pension fund what to do? Do you think that anyone else other than the trustees has that power, or Pauline Zamba was acting at reverse or outside the power?
Through you, Chair, I've looked at the trust deed establishing the fund. There's nowhere where the office of the Secretary to President Cabinet is specifically mentioned. So again, if I were to look at whether she had powers, maybe to give directions like she did, at the very least I would say that's not founded in the trust deed. Those powers are not granted to her. And like I've already said, the powers are vested in the trustees, and they have actually been given absolute discretion to decide on what to invest in. Thank you.
In your submission, you explained that you toed the same line with the Anti-Corruption Bureau. in coming up with your opinion, because the Anti-Corruption Bureau never found any corrupt activities in the process. Do you think that basing your opinion on the Anti-Corruption Bureau in this case was the best decision you could do as the Attorney General? And I'm asking this because assuming that the Anti-Corruption Bureau has missed something, don't you think that then in that case, your decision will also be compromised because you have based your decision on some other office and not your own independent decision?
Through the chair, to begin with, the office of the Attorney General is not an interrogator, is not an investigator. So that's the reason why when I received that complaint from the Malawi Law Society, I referred it to the Anti-Corruption Bureau because they have the capacity to investigate matters to do with corruption or fraud. So there is a presumption of legality that when one thing moves from one properly established office to another, unless something clearly appears to be wrong, you can't just assume that they haven't done the right thing. So the office that's mandated to deal with matters of corruption in Malawi is that of the Anti-Corruption Bureau. So I trusted in their opinion because they are the ones that have got the capacity to investigate. So in my view, remember I said as a legal advisor, you base on facts presented to you. You don't create your own facts. So the fact remains that in their report, the Anti-Corruption Bureau clearly indicated that they did not find any evidence that suggested that there was corruption. So I believe that my opinion was not in any way compromised because of the regularity principle that I had to use under the circumstances.
Two more questions. I think you are holding an office, but you are also a human being and an individual, such that most of the times it's also good to go beyond just the office. As an individual, Mr. Frank Mbeta, the value of the hotel from 30 billion to 47 billion, then to 128 billion, then to 145 billion. You didn't smell any collusion, any corruption in this change of price within 1 year as an individual, not as the Attorney General.
Chair, I'll be quite reluctant to answer, but nevertheless I'll take it because, yes, say there's significant movement. But in my letter to the Law Society, I said it will be difficult for me to fault the pricing because that pricing was done by experts that do the pricing. I personally wouldn't want, and again, with my background as a lawyer, I know that when you're dealing with expert evidence, you really need to have a compilator. You don't just go and begin faulting expert evidence because you would have, as a person, thought maybe it should be done in this way. You normally would want to go to another expert and say, what are we saying here? But that wasn't within the framework of what I could have done. But in addition to that, when you look at some of the prudential risks that the Reserve Bank had raised, they had to do with the price. So when we were saying, can you attend to these issues? We were essentially saying, look at everything holistically and be sure of what decision you are taking as fiduciary persons. So yes, the movement could have raised eyebrows, but corruption is something that ought to be proved, or at least there must be a clear indicator that, or something at least that you can clearly say this points at corruption. So coming from a point where the Anti-Corruption Bureau said we haven't seen any elements of corruption, I didn't really find it as an issue on its own. but also to mention that, in my view, overpricing is not equal to corruption. The hotel may have been overpriced, but of course I don't have the expertise to be able to speak to that clearly. However, there ought to have been some indicators that would actually make you think that there's corruption. So I wasn't able to form that opinion for fear that this is something that was coming from expert assessments. And most importantly, you have the trustees that must actually look into the pricing issue. And also because they negotiated for the price. What were they negotiating for? What were the parameters that they could have used? So remember, that's in their absolute discretion. So I had to stick to my limits. Thank you.
Finally, Chair, what do you think?
Honourable members, I'll give you a chance. Don't worry. Let us allow Blantyre Chiromoni to finish, then I'll get to you. You can formulate substantive questions. Each and every member will be given space to ask. Blantyre Chiromoni, kindly proceed.
I think what's coming out very, very clear is the fact that all the powers to make investment in terms of the pension fund rests with the trustees. That's coming out very clear. And when I asked you about the increase in price, you said the increment in price does not really indicate that there is an element of corruption, but can also indicate that there is very high element of corruption. In your opinion, Attorney General, what do you think is the value of Amaryllis Hotel? That's my last question. Thank you, Chair.
Through the Chair, I don't think I know, or I'm in a position to say what value the hotel could be. Because I'm aware that valuations of businesses that are actually running take so many parameters. So I don't think I would be in a position to say how much it's worth. Thank you.
Thank you, Blantyre Chiromoni, for those submissions. But listening to the Attorney General, you can actually see that there's hibernation of legal formalism. Because in your submission, just listen to you said corruption must be proven. But Attorney General, the idea that corruption must be proven, is it legal? And you went on even to talk of conditional approval. So if you're looking at advice, the advice was conditional approval. Don't you think that was an attempt to shift responsibility as an Attorney General? Because at that stage, it's like you're limiting your mandate. The moment you limit your mandate, then scrutiny stops. Attorney General, is it your position that a transaction is legally sound so long as no evidence of corruption has been detected or established? Over to you, sir.
Yes, I will not divorce myself from the lawyer and me. Corruption, there must be indicators, there must be some pointers which, when investigated, will point at or prove that there was corruption. It is what it is. Just like another offense. That, in a way, was not even limiting my mandate, because to begin with, my mandate in a parastatal, and the trustees have absolute discretion in deciding what and how to invest. So I was not limiting my mandate, but I was merely pointing out to them and emphasizing what had already been pointed to them by the Reserve Bank of Malawi, that there are these issues which they must attend to. I hope I have answered your question, Chair.
Thank you, AG. Your advice centered around risks being addressed, that there are these potential risks. Can you address them on this? Those conditions, do you think at the end of the day, were they addressed that as AG, having highlighted those risks, when you noted that the agreement had been signed and payments have been made against what you had advised, do you feel that at that stage when the payments or the agreement was reached, they had addressed to what you had noted as gaps within what the submissions that you got as AG? Over to you, AG.
Thank you, Chair. It needs to be appreciated that by the time this issue is coming to my office, a SERO agreement, which on the face of it looked to be a valid agreement, had already been signed. But nevertheless, I was mindful that people do actually go through what they've already signed and realize that certain things could be done differently depending on how the agreement has been drafted. So the difficulty there is that it would have been a different scenario if they had come to, this issue had come to my office before they signed. But they had already signed. So there was already a valid agreement between the parties. So when it comes to the addressing of the issues, like I've already indicated, the fund did submit a dossier of documents regarding how they have addressed the issues. However, like I already said again, I was mindful that even if they were to submit those things to my office, the right authority to go through those representations and form an opinion whether they have addressed each and every one of the risks adequately is the governor of the Reserve Bank, because that's the regulator and also with the capacity. That's why in my presentation I said I hope and believe that the regulator has already gone through or will go through those documents to see if those issues were fully addressed. Now, I'm not in a position to know whether by the time that payments were being made and all, this dossier was already given to the regulator and whether the regulator had already gone through them and taken a position on those issues. Thank you.
Chukwawa West.
Thank you very much, Chair. And thank you very much, Attorney General, for your presentation, well detailed. The ACB appeared before this committee and they informed this committee that during their investigations, they didn't find anything about corruption and also something about the abuse of office. The DG went on to say that notwithstanding, it noted some serious risks and referred these issues to you. Maybe for the benefit of the committee, what did you do when you noted those risks? Secondly, you have mentioned that you received a dossier from the fund which contained documents explaining how the fund was had dealt with the attendant risks. For the benefit of the committee, maybe when did you receive the dossier? Thank you very much, Chair.
Thank you so much. Attorney General, you may take those from Chukwawa West.
Thank you very much, Chair. Thank you very much, Chukwawa, Honourable Member from Chukwawa West. Indeed, in the report that the ACB wrote to me, and of course the cover letter, they did indicate that they did not find any elements of corruption or abuse of office, and that they talked about the receipts which they acknowledged were not within their mandate to interrogate or at least form an opinion on, and they referred those issues to me. And that is why, in my letter to the Law Society, the last part which I read, I was telling the fund to attend to those serious risks. So that's what I could have done under the circumstances, because those serious risks had to be attended. Somebody ought to take responsibility for them, analyze them, take positions, or if there are any issues, any things they need to do or to reintroduce into the whole setup in order to deal with those issues, they could do that. And those are the trustees. That's why I told them, can you attend to those risks? The dossier, in my recollection, I think I received them towards the end of February 2026. Thank you.
Honourable members, I had given a chance to honourable members to raise issues. So on the first round, I see a hand from Lilongwe Mpenu. I see a hand from Palombe Machemba. There's Chikwawa North. I see Lilongwe Chirobwe. I see Lilongwe East. We'll start with the Vice Chair. Vice Chair, over to you.
Thank you very much, Chair. Good afternoon, AG.
Honorable.
Thank you, Pana Chair, for giving the people of Machinga Likwenu to ask the AG one or two questions. AG, given the allegations of a suspicious transaction and an exorbitant price stated by questionable valuation from an unregistered company linked to self-proclaimed experts, how do you respond to accusations of deliberately ignoring potential wrongdoing in the hotel sale? 2, what specific measures will you take to investigate these claims, hold those responsible accountable, and restore public trust? Thank you, Chair.
Thank you, AG. On top of that, in your indication, in terms of the pricing, you said the inflation of price in itself is not an indication that there was corruption, but you indicated that you respect the experts. But when you're looking at EMJ, who formed the basis of the transaction, which he had done his work within 10 days and he concluded everything within 10 days. In your view, AG, or are you still standing to your view that you did due diligence? If such a person or such an institution misguided the whole transaction, because everything revolves around EMJ, whose procurement process was faulty, expertise was questionable. Did you at any point when you are doing due diligence engage Secretariat on this person, EMJ? Over to you, Controlling Officer.
Thank you, Chair. I would want to seek your indulgence, the Vice Chair. Your first question, I don't think I've heard you correctly. Would you mind repeating it?
Thank you, Chair. Given the allegations of a suspicious transaction and an exorbitant price seated by a questionable valuation from unregistered company linked to self-proclaimed experts. How do you respond to accusations of deliberately ignoring potential wrongdoing in the hotel sale? Thank you.
Bana Eji, over to you.
So, okay, the part I wanted to understand in that question is the accusation of deliberately ignoring potential wrongdoing. Whose accusations? Towards who? Because so that I am clear in responding.
It's to you too, AG.
Okay, thank you very much, Chair and Vice Chair. Actually, I do not see where, as Attorney General, did I ignore anything in this particular transaction and registered, whether they have correct qualifications or not, is a factual issue. It was never brought to my attention. Even when I asked the fund trustees, they did not suggest to me that EMJ, to their respective boards or whatever, for I could not have ignored what is not known and what is not before me. And again, like I said, when you talk about suspicious transaction, the different allegations made by the Law Society were actually addressed either through the report by the SCB, which made some findings on specific issues, or the Reserve Bank report, which also made findings on various issues. These people actually went out there and investigated. So if those institutions did not label this transaction as suspicious per se, it could not have been proper for me to simply just say this is suspicious. In terms of what action the Attorney General can take, I've said this is a fund established under a trust deed. Only if I am presented with the grounds for which certain actions will be taken, then the actions will be taken in accordance to the law, be it trust law, common law generally, or statutory law as it were. So it will be preemptive for me to take an opinion at this point when facts are all over the place. They're at large. There's this, there's that, there's that. So if I were given a set of facts that this is what we have found, what would you do? I'll be able to advise what the law would allow me to do. Chair, your question on the reflection of price, not an indicator of corruption, and you've talked about being unqualified, the procurement not having been properly done, and all, each one of them, which I would have grounded an issue to do with the procurement processes, and also no ground on which I would have raised an issue to do with the qualifications. Again, like I said, the broader spectrum of qualifications would have looked at issues to do with whether the assessors are properly trained in their field of assessment. Then there are also issues of licensing and all. So those are issues I couldn't just raise anyhow, unless they were brought as a fact. And even the Law Society, in my recollection, I don't remember them raising an issue to do with the qualifications of EMJ. So I only advised on facts that were available. Thank you.
I had recognized Lilongwe Mpenu. Lilongwe Mpenu, please.
Yeah, through Chair, can I take leave of you just like Blanda Chilomoni did? I've got a number of questions. So if I would be allowed to ask the questions one after the other, with your permission, sir.
Lilongwe Mpenu, you will be given that chance because it has been the practice. So, Attorney General, Lilongwe Mpenu, how many minutes? 3 to 5 minutes. 5 minutes. Okay, you get those 5 minutes. Attorney General will proceed like the way we proceeded with the Blanta Chiromoni Kabula Nancholi constituency. Over to you, Lilongwe Mpenu.
Thank you, Chair. Honorable Attorney General, let me begin by saying I do appreciate the fact that your office deals with matters of legal opinion on questions of law as they apply to facts. You cannot cook facts. Facts speak for themselves. In accounting, there is what we call creative accounting, in which the reporter takes advantage of loopholes in financial regulations to inflate profits, deflate expenses, and hide liabilities, for example. So the individual relied on what would be called professional advice from EMJ advisory, for example. Having gathered these facts at this point, and again, it has transpired that let me connect. In your paragraph on due diligence, you failed to mention Nico Asset Managers. I don't know whether that was by design or by default, because the Nico Asset Managers specifically advised against this transaction. So my question at this point is, do you regret having given advice, legal advice, based on EMJ, who it happens is not registered? And then there were other advisors who specifically advised against the sale. Maybe you can take it.
Chair, regrets on relying on EMJ reports. I think that's a question that probably the right people that should have answered it are the trustees, because they are the ones that place reliance on that valuation. I was not in a position to place reliance on that, but I recognize the fact that they had engaged a business valuer, just as they had engaged other valuers before. So that regret, or perhaps a question of whether there'll be regrets or not, I'm sure the trustees would be in a better position because they are the ones that made the decision at the end of the day. The issue of not mentioning Nico Asset, you notice that I've mentioned the FDH. Remember that Nico Asset, from what I gathered, they did not do the evaluation of the business themselves, FDH. So if you were to look at a report, you will not be looking at a report, at least what I was presented with, you will not be looking at a report that is done by Nico Asset per se. It's a report done by FDH on behalf of Nico Asset. So I was mindful that if we are looking at what business report, evaluation report was made available, I did not see one that was done by Nico Asset. It is FDH that did the evaluation, at least from the facts that I gathered. So again, those are the facts that I had.
Chair, in your response to the Malawi Law Society, it appears it was cut and paste from the letter written to you by the Acting Director General of the Anti-Corruption Bureau. Yet, as an office, you had the latitude to conduct your own due diligence to ensure that your response to the Malawi Law Society, for example, was your own and not necessarily that of the ACBs. And Chair, that question also builds on the fact that it has transpired that the ACB now acknowledges that through these interfaces, certain facts that they didn't have emerged. As a result, they have reopened investigation.
What's the question? Because I think you made a statement. The question is?
I asked a question that your office could have conducted your own due diligence to ensure originality of your response to the Malawi Law Society instead of depending on the response to you by the ACB.
Thank you, Chair.
Maybe, AG, before you take that one, just to supplement on what has touched on, that the ACB has reopened the case, and at the same time, the Reserve Bank, which is a regulator, has actually withheld the funds. As we're speaking, we're looking at about 72 billion. With the guidance that you got about the whole transaction vis-a-vis the pricing that it was higher, do you still stand to your earlier position that the transaction was not was okay? There were no corrupt elements. Now that you have new information that even the Reserve Bank has ended up quarantining and actually freezing some of the accounts in relation to the same. Over to you, controlling officer.
Thank you, Chair. Honorable member from Lilongwe Mpenu, I take it when you say that we could have conducted our own due diligence, you essentially are talking about our own investigations. Is that the context in which you are asking that question?
Not necessarily your own investigation, but having been presented with the facts, you needed to dig deeper than just relying on the submission from the Office of the Anti-Corruption Bureau in your response to the Malawi Law Society. That's the context.
In my letter to the Law Society, you will notice that I did indicate that I also did my own investigations. So what I found mirrored what the ACB found, because remember that the people that were being interrogated are more or less the same people. And the same findings were repeated in the report by the Reserve Bank governor. Again, it's because we were all questioning the same people. They gave the same answers. So, to emphasize that I did investigate, and the answers given at that point were more or less the same as those that ACB brought, more or less as those that were found in the report by the Reserve Bank of Malawi. The facts played out in that fashion. So I couldn't have presented facts any different when they just played out in the manner they did.
Officer, can you switch off your mic? When you're looking at the facts that they were similar, did you go through the submission by Malawi Law Society, where it actually raises concerns that the EMJ was a collusion, in their view? If you go through the Malawi Law Society submission, it actually indicates those things. So when you're looking at EMG, in your, if it was similar, whatever, because you're engaging probably the same individuals. In that report, did you find, in your view, that the EMJ was an expert? And as you're talking of those findings, did you manage to refresh yourself in terms of the period EMJ took to arrive at providing such an independent expert submission? Over to you, AG.
Okay, the issue of EMJ being a collusion, I think that's an allegation that at the material time when the Law Society wrote to me, they didn't talk about collusion. So I wouldn't have imagined that an assessor that would actually be contracted to assess such a business, a huge business, as it turned out, would have been collusion, unless if they had raised it, because the things that they did raise, they were attended to. So the collusion part is probably, that's what maybe they presented in their submissions here. But if you're in my shoes at the time when I was giving my opinion, you would appreciate that I couldn't just pluck this from somewhere. There wasn't such an issue. Yes, I'm aware the RBM has frozen the funds. The SCB has reopened the investigations. But perhaps just to be sure, at this point, do we have anything that already points at that elements of corruption have been established? Or we are still waiting for those investigations? Chair, I just wanted to be clear in the question in which, in the manner in which this question came through on the issue of corrupt elements.
Basically, you're looking at the Reserve Bank rescinding the decision, or still towing along what they had advised, that this transaction was not supposed to proceed because there were elements which pointed to corrupt acts, to the extent that having noted that they had advised, but the board proceeded with a sale agreement. In fact, your office actually advised on not to, unless few other things were handled. But the fund proceeded to actually sign a sale agreement where even Malawi Law Society had raised issues of conflict of interest with EMJ and the owner of the hotel. All those things are contained in the submission that Malawi Law Society gave to Parliament. So I thought you are aware of some of those things and elements. The more reason I wanted to find out from you that having had that the regulator now of financial institutions has quarantined some funds, even with the banks which were involved, even other individuals, including the account for Amaryllis Hotel. Do you still feel that the guidance that you got was valid? Thank you, AG.
Yeah, thank you, Chair. The difficulty in the line of question that has been made there is that an opinion is being sought based on precautionary steps taken by the Reserve Bank as well as the SCB. I would think that giving an opinion has to be based on facts, the actual facts that go to the root of the issue. As I sit here, I do not have any document, official document, either from the Reserve Bank or from the SCB that actually details out let's say, elements of corruption, who was involved, what they did, and everything else. It will be difficult to form an opinion unless such facts are made available. And again, freezing of funds, like I said, it's more of a precautionary measure. It depends on so many factors at play. And I haven't seen the documents that the ACB, rather the Reserve Bank, has used in freezing the funds. I don't know whether they obtained a court order or maybe they went through the Financial Intelligence Authority, which probably seems to be what I gathered. So in all that, there are some facts that are speaking to that decision to freeze the funds, which I do not have now. So again, I cannot just form an opinion. If those facts were made available, I would certainly form an opinion. But then as far as the opinion that I formed on 28th December 2025, it was correct to the extent of the facts made available. Thank you.
Lilongwe Mpenu, can you wind up? Your 5 minutes is almost done.
You intercepted me, Chair. Well, it's constitutional duty to ensure legality and procedural compliance that the fund engaged EMJ to conduct an evaluation in the Amaryllis transaction when EMJ was not registered as a valuer in accordance with the relevant statutory framework governing professional valuation practice in Malawi. And further, if the applicable law requires that proper valuation be undertaken only by duly registered valuers, does the engagement of EMJ not raise questions as to the legality, validity, and enforceability of the valuation relied upon in the transaction, and consequently due process? Whether due process was observed. AG, you submitted to this committee that you are confined to the legality. So this question builds on that. And I'm asking, okay.
Still on the mic, so that's why I was waiting.
Okay, sorry. My
Thank you. Okay. The fact of EMJ not being registered under whatever framework, it is a fact that ought to have been made available if it were to change the opinion that I would have formed at that time. It wasn't there, so it remains what it is. It was never there. So I couldn't have formed an opinion on what is not known or what is not made available. But again, you might wish to know that the Reserve Bank, as a regulator, they do have wider powers. Maybe that's why they do register some of these valuers. And in any event, in the letter that I saw, firstly in the report that they sent to me on 25th December 2025, as well as the subsequent letter which they wrote to me on 6th January 2026, but received on 10th January 2026. The Reserve Bank didn't come out clear-cut to say rescind the transaction or this transaction can never be done. They said, can you address the risks? And in particular, the letter of 6th January 2026, the governor said, satisfy my office on the viability of this transaction. He didn't even talk about the EMJ advisory. So again, we're still at the point where the information made available would influence the nature of opinion that you give on something. So this doesn't in any way compromise the consistency of my constitutional duty to provide legal opinions. Now, the issue of whether EMJ not being registered will affect validity, enforceability, and due process of this agreement. Firstly, I must put a disclaimer that I'm not giving an opinion per se, because you have several players here. You have the seller on one side, and then you have the buyer, and then you have the Reserve Bank of Malawi as a regulator. The legal framework that the regulator looks at when it comes to managing financial institutions points at the financial institution. Have they done ABCD correctly or not? And if they find that they haven't done the correct thing, what are the remedial measures? Which is why you will notice that in the most recent letter I saw from the governor, where he suggested that suggest, direct or whatever, say to the pension fund, can you have so much number of days to rescind the contract? He did mention that satisfy me why I should not penalize you. That speaks to the regulatory framework that the governor uses when it comes to financial institutions. So the example would be, if you own a bank and you do some illicit forex transaction, the governor will not go to me as a person who bought the forex from you to say, you bought wrongly, can you give us back the dollars? They will go to you as the financial institution and penalize you. So the point I'm making is, it is important to understand the legal framework in which these things are arising. What the governor would do is properly regulated by law, but against who? What is very clear from all the laws that the governor would do, they point towards the financial institution, because that's their subject. That's what they are regulating. That's what they're mandated to regulate. On the other hand, you have the seller. So in law, we talk about the famous Tarquin case, so we talk about the Tarquin principle. There are issues to do with indoor management rules. So all these things that we're debating here, they have to do with how the fund or the trustees conducted themselves in making their decisions, which is an internal issue within the trust fund. On the other hand, you have the seller who offered and eventually negotiated with these trustees for whatever price that they could have offered on, and eventually did agree with the buyer. The court, probably at an appropriate time, they may have to examine how does the indoor management rule come to operate in respect to this particular transaction, because then that will affect the issue of validity, enforceability, and due process. So it is important to understand that when you look at the fund, which is what we are questioning now, what they do internally and eventually enter into a contract with the seller, the regime that we're going to use in terms of the legal regime is different. So it is pretty much difficult for me to say whether this contract will remain valid or enforceable, because you would have to examine all the facts, as well as look at what legal framework are you using. Because the other legal framework does not go directly to the seller. The seller is not a financial institution. The Reserve Bank governor does not have automatic powers on the seller. So it's important that these things be understood in their context and the legal framework that's being discussed, and therefore I'm unable to give an opinion on the issues of validity, enforceability, and due process in respect to the fact that EMJ was not licensed. Thank you, Chair.
Yeah, my last but one question. ACB in their submission, they said they observed that some of the matters that had to be investigated were out of their mandate. For example, issues of investment and fraud. And they submitted to you as AG to take the same to relevant offices. or take appropriate action. What did you do after receiving the submission from the ACB? Did you, for example, advise the Financial Intelligence Authority or Fiscal Police to investigate? If you did not, why?
Chair, I did mention that the issues that the ACB said were out of their mandate, they had to do with the very issues that are within the mandate of the Reserve Bank of Malawi. And Reserve Bank of Malawi had sent me a report on 25th December dealing with those issues. So there were answers. They were attended to because the bank was conducting their own investigations, whilst the ACB was conducting their own investigations, which is why I emphasize that when I was forming my opinion, I waited, apart from having an interface with the trustees and everybody else I could ask questions regarding this issue, I waited for reports from the ACB and the Reserve Bank of Malawi, because these issues that ACB is saying it's out of our mandate, they were already dealt with by the Reserve Bank in their report. And that's why they did recommend that those issues have to actually be attended to. And that's why I actually told the fund, attended to these issues. So there was no need to tell FIA or Fiscal to go and investigate issues that already fell within the mandate of the Reserve Bank, and the Reserve Bank had actually addressed them in their report. Thank you.
Lilongwe Mpenu, I'll ask you to share that one so that we go to Lilongwe Chirobwe, Palombe Machemba, in that order, please.
Thank you, Chairman. Through you, I would like to ask the Attorney General, who was the expert who recommended the price of 128 billion from 47 billion?
Can you switch off your mic? Honorable Eji?
Maybe a bit of clarity on that question. I'm failing to pin it down properly. If you could take it again, maybe in a summarized fashion.
In your submission, you mentioned about the expert advice on the price when you were asked by Blantyre Kabula about the 128 billion being a red flag. You said no because you were taking an expert advice. I would like to know who was this expert who gave you this advice on the 128 billion?
Chair, the price range of 115 billion to 147 billion, that was, I think, what I saw in the documentation from EMJ. So they were not advising me. This is, they were advising the fund. So I was saying in my earlier statement that these were deemed as experts in the valuations. So that's where the issue of experts came in. So from the best of my recollection, that price band came from EMJ advisory. Thank you.
The Attorney General, are you aware about the EMG status?
Perhaps if you could be specific, which status?
That they are not
Do you want time for one-on-one, or what is this? Because I see you're just going straight to the controlling officer. That's unprocedural, because I haven't given you that chance.
Thank you, Chairman. As you have put the precedence before some that have spoken for me, I would like to ask you, the chair, to give me enough time, like 10 to 15 minutes, so that I can ask the Attorney General.
Lilongwe Chirobwe, will not give you 15 minutes. I can give you 8 minutes. So, honourable members, you may recall that members have asked even 10 minutes in this committee. So he's asking for 15 minutes. I'm saying we'll give you almost half of what you've asked. So we'll give you 8 minutes. Chukwa West, background noise, please. Proceed, Lilongwe Chirogwe.
Thank you. You as well said about the SPC that cannot provide oversight because it is not written anywhere. Why were you advising the fund?
You notice that even in my letter dated 28th December 2025, I begin by acknowledging that there was a complaint brought to my office by the Malawi Society. That's where my office got involved in this matter. If there was no complaint, there was no way I could have just jumped in and said, Trust Fund, what are you doing? I couldn't. So that's why I did use the language. My involvement was not proactive, it was reactive. So in terms of the powers of the SPC, I'm sure at an appropriate time, the SPC will come here and answer the questions, how she got the powers, but I was simply saying, when I combed through the first bit, she is not being specifically mentioned. I think that's what I said.
Okay, you are saying that overpricing is not a sign of corruption. Are you sure a jump from 47 billion to 120 billion did not amount to corruption? Where would the AG stop government funds from being stolen if this is not corruption?
Chair, again, I maintain my position. Valuations were done and figures were presented. So I can't just say this is corruption. And perhaps to appreciate the fact that, Chair, you've already advised that the ACB is also looking into the matter again, I'm sure if there was corruption, it will be unearthed and appropriate action will be taken. Thank you.
In your response to Malawi Law Society, you said you will investigate. Who did you consult in your investigations?
I mentioned, Chair, in my letter that the SCB were actually part of the investigations because they did the conduct. That's why we have a report. But on the other hand, maybe up to now you may have noted that the report by the Reserve Bank, I haven't seen it anyway floating. If it was made available to this committee, probably it would have been floating somewhere. It's